Good afternoon, and thank you for joining us for an MP webinar covering 2023 FLSA Overtime Changes, What You Need to Know. I'm Brianna Hostler, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee lifecycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions as well as proactive, reliable service and deep HR and payroll expertise. At MP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to introduce your presenters for today's program, Paul Corrales and Emily Madrini. Paul has over a decade of experience in the HR consulting space, working with businesses of all sizes and industries. Paul leads a team of SHRM certified HR professionals at MP. Together, they assist clients with compliance, training, and HR guidance and support for the full employee lifecycle. Paul also spearheads MP's employee retention tax credit services. This initiative has helped thousands of clients claim over $100 million in refundable, advanceable tax credits. Emily is an HR generalist at MP. She currently provides HR support to small, medium, and large-sized businesses in a variety of industries. She has her BA in Human Resources Management and has worked in the HR field since 2016. Just a few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out the recording of the webinar later today along with the slides. And with that, I hand the mic off to Emily.
Good afternoon, everyone. Welcome to today's webinar. Thank you so much for the introduction, Brianna. And as Brianna stated, I am Emily, and I'm super excited to be presenting this topic to you all today with my partner in crime, Paul, and I will be kicking us off first with this webinar. So about halfway through, I'll transition it over to Paul to complete the webinar, and I just thank you all for being here. And without further ado, let's go ahead and get into today's topic. 2023 FLSA Overtime Changes and what you need to know. First, I'd like to discuss today's presentation topics. We're going to start out with an introduction to the FLSA, Fair Labor Standards Act. What is it? Who does it pertain to? Who is it enforced by? And then we are going to dive into white collar exemptions, as well as what the proposed changes to FLSA overtime rules are and where we may be currently at in the process of getting those changes solidified. Then we will be discussing overtime pay and some common mistakes employers make, and ending it with some record keeping and enforcement guidance. Before we jump into the FLSA, it's important to note that the focus of this training is for federal regulations only, and employers do need to be aware of the state and local labor laws in all locations where you have employees. I just like to throw that out there as a disclaimer to keep in mind. All right, so let's get into the introduction to the Fair Labor Standards Act. So we have a little bit of background knowledge here to begin. The Fair Labor Standards Act is a federal labor law enacted in 1938 by the United States Congress. Its primary goal is to protect the rights of workers by establishing certain basic labor standards, including minimum wage, overtime pay, and child labor regulations. The FLSA is enforced by the Wage and Hours Division of the U.S. Department of Labor. The FLSA does not require employers to provide time off for holidays, vacations, or sick leave, meal periods or rest breaks, premium pay for weekend or holiday work, notice prior to termination or layoff, and pay raises or fringe benefits. It is essential to note that while the FLSA does not require employers to provide the above listed items, state and local laws, again, may have additional requirements on these matters, and employers must comply with both federal and applicable state labor laws to ensure that they are meeting all relevant obligations related to employee compensation and benefits. The purpose of the overtime regulations is to protect workers' rights, promote fair labor practices, and provide appropriate compensation for employees who work beyond regular working hours. Overtime regulations are a crucial component of labor laws that seek to balance the interests of employers and employees, promote fair wages, and safeguard the well-being of the workforce. By providing a framework for fair compensation and reasonable working hours, overtime regulation contributes to a more equitable and sustainable labor market. On the importance of complying with labor laws and what those implications may be, I'd like to go into a bit more detail on these subjects discussed in the previous slide. So here are just a few of them. Worker protection. Labor laws are designed to protect the rights and interests of employees. Compliance ensures that workers receive fair wages, again, that overtime pay, benefits, and safe working conditions. It safeguards them from exploitation, discrimination, and harassment, promoting their well-being and dignity in the workplace. Legal compliance. Failure to comply with labor laws can lead to severe legal consequences, including fines, penalties, which I will be discussing a little bit more in depth in the next slide, and potential lawsuits. By adhering to these laws, employers can avoid costly legal battles and reputational damage. Avoiding reputational damage. Labor violations can severely damage a company's reputation and brand image. Negative publicity related to worker mistreatment can lead to public backlash, customer boycotts, and just a loss of trust among stakeholders. On the other hand, a reputation for fair treatment and labor law compliance can attract customers and employees. Employee satisfaction and retention. Complying with labor laws fosters a positive work environment, boosting employee morale and satisfaction. Satisfied employees are more likely to remain loyal to the company, which in return reduces turnover and recruitment costs in the long run. Fair competition and business stability. Complying with labor laws creates a level playing field for businesses. When all companies adhere to the Sesame labor standards, unethical employers cannot gain a competitive advantage by cutting corners at the expense of workers. A stable business environment with fair competition promotes long-term business sustainability and economic growth. There are also other factors to consider when complying with labor laws, such as long-term sustainability, social responsibility, and attracting talent. The list goes on. But overall, compliance with labor laws is not just a legal obligation, but a fundamental ethical responsibility. And prioritizing all of these factors enhances overall success and makes a positive impact on the organization. Here are some of those penalties that were mentioned in the above slide. Willful violations may be prosecuted criminally and the violator fined up to $10,000. A second conviction may result in imprisonment. Violators of the child labor provisions are subject to a civil money penalty of up to $10,000 for each employee who was the subject of a violation. And employers who willfully or repeatedly violate the minimum wage or overtime pay requirements are subject to a civil money penalty of up to $1,000 for each violation. So these are huge and very severe penalties and examples of why we want to comply with labor laws the best we can. The next topic we're going to be discussing is the FLSA providing exemptions from overtime rules for certain workers, often called or known as white collar exemptions. This is also the most common type of exemptions from overtime. So let's dive a little bit deeper into this. First, we'll review the most common white collar exemptions, which includes executive, administrative, learned professional, creative professional, computer professional, outside sales, and highly compensated employees. There are many other specific exemptions, which you can find on the DOL website, and a link will be provided on a slide at the end of this presentation for your review. The FLSA outlines a three-pronged test to determine whether an employee is exempt. Most employees must meet all three tests to be considered exempt from overtime rules. First is the salary level test. Generally, employees who are paid less than $35,568 per year are non-exempt, and employees who earn more than $107,432 per year are almost always certainly exempt. Remember, again, that state and local law, wage and hour laws may be different. Second is the salary basis test. Typically, an employee is paid on a salary basis if they can count on receiving a guaranteed minimum amount of money for any work week in which they perform work. That means you cannot deduct from an exempt employee's pay based on the number of hours worked, with limited exceptions. The third and final is the duties test. Each exemption has specific duties that must be performed in order to be considered exempt from overtime pay. Job titles or position descriptions are not that useful to determine exempt status, and it is the actual job task and how the job fits into the employer's overall operations. I commonly tell my clients, if they do have an FLSA audit, they're going to come in and they're going to ask the employee what they do on a day-to-day basis. And it isn't going to matter what their job title or what their job description may say. So that's something really important to keep in mind. In addition to meeting the salary level and salary basis test, to qualify as an executive exemption, the employee's primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. Customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent, and authority to hire or fire other employees or the employee's suggestions and recommendations as to the hiring, firing, advancement, promotion, or any other change of status of other employees must be given a particular weight. So you might be asking, what does that particular weight mean? So that is factors to be considered in determining whether an employee's recommendations as to hiring, firing, advancement, promotion, or any other change of status are given a particular weight, include but are not limited to whether it is part of the employee's job duties to make such recommendations, and the frequency as well with which such recommendations are made, requested, and relied upon. And employees' recommendations may still be deemed to have particular weight, even if a high-level manager's recommendation does have more importance, and even if the employee does not have authority to make the ultimate decision as to the employee's change in status. In addition to meeting the salary level and salary basis test, to qualify as an administrative exemption, the employee's primary duty must be the performance of office or non-manual work directly related to the management or general business operations of the employer or the employer's customers. And the primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So to meet the directly related to management or general business operations requirement, an employee must perform work directly related to assisting with the running or the servicing of the business as distinguished. Some examples would be working on a manufacturing production line or selling a product in a retail or service establishment. In general, the exercise of discretion and independent judgment involves the comparison and the evaluation of possible courses of conduct and acting or making a decision after the various possibilities have been considered. The term must be applied in the light of all facts involved in the employee's particular employment situations and implies that the employee has authority to make an independent choice free from that immediate direction or supervision. Factors to consider include, but are not limited to, whether the employee has the authority to formulate, affect, interpret, or implement management policies or operating practices, whether the employee carries out major assignments in conducting the operations of the business, whether the employee performs work that affects business operations to a substantial degree, whether the employee has authority to commit the employer in matters that have a significant financial impact, and whether the employee has authority to waive or deviate from established policies and procedures without prior approval, and then some other factors as well that are set forth in the regulation. The term matters of significance refers to the level of importance or consequence of the work performed. An employee does not exercise discretion and independent judgment with respect to matters of significance merely because the employer will experience financial loss if the employee fails to perform the job properly.
I did just see one question come up that I can field now while it's fresh. So
Sure, go for it.
A participant asked, with the executive exemption and the requirement for 2 or more full-time employees or equivalents be managed by this person, does that include volunteers or only paid employees? So the DOL field operations guidance does say that it has to be paid employees and employees of the organization. So volunteers, employees of independent contractors, interns, trainees, other non-employees are not considered eligible when determining the managerial authority of someone trying to qualify under the executive exemption.
Thank you, Paul. Now we'll be discussing the learned professional exemption, and feel free to ask questions throughout. We're happy to do that. It helps with engagement and interaction, so we're all for that. But there will be some time at the end too to discuss questions as well. But in addition to meeting the salary level and salary basis test, to qualify as a learned professional exemption, the employee's primary duty must be the performance of work requiring advanced knowledge, defined as work which is predominantly intellectual in character and which includes work requiring the consistent exercise of discretion and judgment. Advanced knowledge must be in a field of science or learning, and advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. And there is a quick note. I just want to say the salary level and the salary basis requirements do not apply to certain job positions such as teachers, doctors, or lawyers. So definitely something to keep in mind. But in relation to the work requiring advanced knowledge, this just means that work is predominantly intellectual in character, and it includes work requiring the consistent exercise of discretion and judgment. The field of science or learning includes law, medicine, theology, accounting, engineering, architecture, teaching, various types of physical, chemical, and biological science, pharmacy, and other occupations that have a recognized professional status and are distinguishable from the mechanical arts or skilled trades, where the knowledge could be a fairly advanced type, but is not in the field of science or learning. And then the customarily acquired by a prolonged course of specialized intellectual instruction. This is when the learned professional exemption is restricted to professions where specialized academic training is a standard prerequisite for entrance into the profession. The best evidence of meeting this requirement is having the appropriate academic degree. However, the word customarily means the exemption may be available to employees in such professions who have substantially the same knowledge level and perform substantially the same work as the degreed employees, but who have obtained the advanced knowledge through a combination of that work experience and intellectual instruction. To qualify as a creative professional exemption, the employee's primary duty must be the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. Under the creative professional exemption, individuals may also be paid on a fee basis, which is just a lump sum for completing a single job, regardless of how many hours they have worked. However, to meet the salary level test for the exemption, the fee payment must equate to at least $684 each week if the employee works 40 hours. And a recognized field of artistic or creative endeavor. This just includes fields such as writing, music, acting, and the graphic arts. Computer professionalism exemption, they are compensated either on a salary or fee basis at a rate not less than 684 hours per week as well, or if compensated on an hourly basis, that's a rate of not less than $27.63 an hour. And then employed as a computer systems analyst, computer programmer, software engineer, or other similarly skilled worker in the computer field performing the duties described in the next slide. Those primary duties consist of application of systems analysis techniques and procedures, including consulting with users to determine hardware, software, or system functional specifications, design, development, documentation, analysis, creation, testing, or modification of computer systems or programs, including prototypes based on and related to user or system design specifications, design, documentation, testing, creation, or modification of computer programs related to machine operating systems, or a combination of the aforementioned duties, the performance of which requires the same level of skill. So these are very particular and specific. So definitely another thing to keep in mind when identifying exemption for computer professionals. And the last exemption we'll be talking about is outside sales. So away from employer's place of business, an outside sales employee makes sales at the customer's place of business, or if selling door to door at the customer's home. Outside sales does not include sales made by mail, telephone, or the internet, unless Such contract is used merely as an adjunct to personal calls. Any fixed site, whether at home or office, used by a salesperson or a headquarters or for telephonic solicitation of sales is considered one of the employer's places of business, even though the employer is not in any formal sense the owner or tenant of the property. And with that being said, I'm going to go ahead and transition it over to Paul to discuss changes to the FLSA overtime rules for 2023.
Awesome. Thank you so much, Emily, and great job explaining what is certainly some complex aspects of employment regulations. Got a lot of good questions in there that we will get to as many as we can at the end of the presentation today. So a little bit of a spoiler alert here. We plan out our webinar schedule a few months in advance, working closely with the various teams here, and they pick the HR team's brain to talk about what will be relevant and topical and of value to the business community. So I think when we plan this one out, we were probably around the month of May, and we were supposed to be getting some changes to the overtime rules in May. And then shortly after this, they pushed it to August. So we thought, okay, we'll be doing it in August. We'll have the proposed rules in August, but unfortunately, those have not been published as of about an hour ago when I last checked the Federal Register for updates and proposed rules that were submitted. They are not there yet, but we will talk about it. We'll talk about maybe what the reason is for the delay. We'll talk about what we're hearing in terms of rumors about what might be included in the changes, and then how to best prepare and get ready for the changes when they do inevitably come. So in terms of the most recent real changes to the Fair Labor Standards Act, was in 2020 during the Trump administration. So you may recall a few years prior to this, I believe it was 2016 or 2017, the Department of Labor under the Obama administration had put in place a rule that was set to take effect in December of that year that would have dramatically increased the standard salary level for the salary test. So at the time, it was $455 per week, and it was going to become $913 per week, so more than doubling. So what would have happened in that circumstance is that the minimum salary that someone would need to be paid to be considered exempt, aside from the duties test, would be $47,000 and change. So what happened just weeks, maybe a week before that was set to take effect, and after many businesses had already made some plans, rearranged things to become in compliance with this, a federal court knocked it down, put on a hold, and then eventually it was completely eliminated. So that never came to be. The Department of Labor under the Trump administration did revisit it, did something a little less dramatic, and it was challenged in court, but it has been withheld. So as of 2020 and beyond, and as of right now, the minimum salary that an employee needs to be paid before looking at the duties test is $684 per week, which is an equivalent of $35,568 per year. They also bumped up the highly compensated employee. So it used to just be $100,000 even. If someone made more than that, then and were paid on a salary basis, then as long as they met a little bit of the duties test, then they were generally deemed okay because they were highly compensated. Another point here that didn't make it on my final slide, another impactful change that actually just happened in February of this year. It wasn't done by the Department of Labor, but was instead done by the Supreme Court. There was a Supreme Court case last year and into this year where a business, I believe it was an oil company, and for folks working out on an oil rig, they were paid a daily rate. So they weren't being paid on an hour, they were being paid based on the days that they work. And the individual that sued worked many hours, was paid very well, made over $100,000 per year and over $107,432 per year, but wasn't paid a weekly salary. They were instead paid on a daily rate. So he sued, saying that, technically that isn't a salary basis if you're paid a daily rate. And so he felt he was entitled to a whole bunch of overtime for all the hours he worked. This was decided by the courts, appealed. made its way all up to the Supreme Court, and ultimately the Supreme Court ruled in favor of the employee. So it is important to note that if you are paying employees a day rate, which is allowed, you can pay people per piece, per day, whatever. But if they're otherwise a non-exempt employee, if they don't meet the duties test, then you still need to be tracking their hours. And if those hours exceed 40 in a work week, then you need to calculate that daily rate and how many hours were actually worked and come up with an overtime calculation for those individuals. So short of paying someone a true guaranteed salary, with some exceptions, like Emily discussed with the computer workers and outside sales and some others, anything short of a full weekly guaranteed salary is going to run the risk of being out of compliance with the exemption rules. So the update that we're anticipating and waiting on dates all the way back a couple years to the fall of 2021. That's when they announced that they were going to propose some changes to the Fair Labor Standards Act and to the overtime rules. Ever since then, as we've seen, it's been pushed back numerous times. And most recently was May, when they said that the proposed rule will be in August. So we still await this. The good news is for registering for this webinar, you will be the first to know as soon as something comes out. Again, we're keeping a very, very close eye on these proceedings and on the rulemaking process. So as soon as we get something, we will get that out to all these attendees. We'll likely have another session like this solely based on the changes. And you will have some time to prepare. So generally what happens is the rule is proposed. There's then a 60-day or longer public comment period where members of the public can voice their opinions on the proposed changes. Sometimes the agencies will have listening sessions, either virtually or in person around the country, where there'll be a representative from the agency there to hear from the public about their thoughts on the changes. And then they will go into final rulemaking process. The final rule will be published with an effective date. So realistically speaking, if they do stick to the August, sometime this month, timeframe of releasing the proposed rule, we wouldn't likely see an actual change to the rules take effect until probably early 2024 would be an effective date. I will say, based on some other recent actions, they're not stuck to starting something on January 1st of the year. That one that was shot down back in 2016 was set to take effect December 1st. So they won't necessarily be respectful of calendar year changes and things like that. So just keep that in mind. So this is just, a matter of opinion here in terms of what some of the potential reasons for the delay could be. The first is a fairly significant one. So as you may have known, the original Secretary of Labor nominated and confirmed under President Biden was Marty Walsh. So for those of you in New England, he was the mayor of Boston and left that position to become the Secretary of Labor. He has since left that for another opportunity. So nominated in his place was the Deputy Secretary, who is Julie Su. So she is serving right now as the active secretary. So she is in there working with folks. But it sounds like there may be some just some difficulty with her confirmation, or some people may be opposing her confirmation to that position. So it isn't necessarily a slam dunk. So with that might be causing a delay. They may want to wait until that confirmation is finalized before releasing the proposed rule. There could also be some internal disagreements depending on what they're looking to change with the FLSA. Also, there's a very high likelihood, if not a certainty, that whatever they do propose will be challenged legally. Even the fairly modest change by the Trump administration was challenged in court, as I mentioned before. So if they do that or anything in addition to that, there will certainly be states or other folks who wish to challenge the proposed rule in court. So with that, they want to make sure that everything they're doing, that they have a legally sound argument for and are prepared to defend their position. And then it also might be because they're planning more dramatic and aggressive changes than we've seen with some of the previous proposed rules. So the last couple of times, all they've done is raise that salary level. So what might they be thinking in terms of other potential changes? They could be planning another large increase in the minimum salary. So rather than something that they feel will need to be updated again in a couple of years, they might either do it all up front now and put a large increase effective soon. They may also do some automatic indexing of that salary figure. So as the consumer price index or something similar, some legal experts feel like they might try to tie in some automatic increases annually, every 2 years, every 3 years, every 5 years, something like that, where based on what the CPI is or another standard measure that for inflation and cost of living and other things that might have automatic increases built in. There is also a distinct possibility that there could be some changes to the duties test. So all of those things that Emily so expertly reviewed in terms of what qualifies someone to be exempt based on their job duties. If they're looking for examples from the states, California has a rule in place where at least 50% of an exempt worker's job duties have to fall into those exempt descriptions, that at least half of their job has to be performing exempt duties. If they fall short of that, if they're only supervising or managing 25% of the time, let's say, then that negates the exemption there. So they may do something mathematical like that. They may also make some changes to better define or more narrowly define some of the duties tests. They may create new exemption types. So one thing you saw, that last one that Emily went over was the outside sales exemption. And it's important to point out that it is strictly an outside sales exemption. If you have inside sales folks, there is not an exemption for that. That's generally seen as a non-exempt position. There are some states, I believe California is one of them, that does have their own inside sales exemption, but again, definitely some room for interpretation also with the computer workers. I mean, technology and computer-based jobs have transformed so much over the last year, let alone the last 10 or so. So there could be some updates to the computer worker exemption as well, and the duties that are considered exempt in nature. So what can we do to prepare as we wait, as we bite our nails here, waiting for the DOL to give us what they've got? While Emily is correct in that job descriptions only play a small role in determining whether or not a business is compliant, they are important to have and an important first step in the process. So definitely review those. If you don't have them, create them. If you have them, but it's been a while, update them. You really do want to make sure that the job descriptions match what employees are doing on a day-to-day basis. So especially as we're coming out of the pandemic here, so many people's responsibilities changed, whether that be adding a virtual component or a business that had to be reorganized, and now someone who was wearing 2 hats is now wearing 3 hats, or whatever it may be. So as Emily said, really most, if not all, Department of Labor audits nowadays involve some level of employee interview. So as part of their information gathering and getting all your payroll records and job descriptions and handbooks and whatever else they're asking for, they will ask for contact information for the staff as well. And we have seen them truly reach out to those folks and ask them some questions. So you do want to make sure that if you do have job descriptions, first pat yourself on the back. Those are a great HR infrastructure tool to have in place. But at the same time, do make sure that they're accurate and updated. Next, it's a good idea to run compensation data. So whether that's making sure that your roles are competitive from a salary perspective in your industry and in your geography, just a good idea to get a good handle on that as you prepare to make some decisions. So let's say the salary test is bumped up significantly, like it was proposed to be 6 or 7 years ago. That left some people with some difficult decisions, with people that did meet the duties test, but were paid quite a bit less than that new salary number. Is this a situation where we're going to give these people increases? Are we not being competitive with our pay? Is this something that justifies an increase, or are we going to switch these people to non-exempt? And then with that comes a very what needs to be a very well thought out communication plan for delivering this news to the employees, whatever changes are going to be made to be in compliance with the changes to the FLSA. Also a good time to do a pay equity audit. If you're making changes to people's statuses, people's pay, people's job descriptions, especially in this day and age, people compare notes, they talk to one another. So you want to make sure you don't have any pay discrepancies that could rise to the surface as you're making changes. And then, if this is something that you haven't been watching very carefully, definitely take a look and review. Are employees that we're paying as exempt under the current rules, or do we potentially have some exposure or liability here? I will say, it's always best to become in compliance as soon as you realize that you're not. But depending on the timing here, if we're on the precipice of some changes and we know what those changes are going to be, sometimes it can make the communication a lot easier that you're updating in line with the new rules, even if you may have been out of compliance prior as well. So just a good time to look at this. And if you do find yourself out of compliance, this could be good timing to get yourself in shape and in a good position there. All right, so in terms of common overtime mistakes, and there are several, and the Department of Labor has been very busy over the last couple of years. I've talked to many businesses and business owners who have been audited, and really they provided some valuable insight into what these auditors tend to be looking for. And before I get into the overtime stuff, I'll definitely say there's been a big focus on child labor. They've been saying that in press releases and in their published agendas, that especially in fields where there tend to be a lot of underage workers, hospitality, restaurants, retail, certain agricultural jobs, that they've made it very clear that it was going to be a big initiative of theirs to really focus on child labor. They recently, just a week or two ago, published that in the months from October until now, there's been a 44% increase in discovered child labor violations by the Department of Labor. So they're looking at it very carefully. They are finding folks. They're working with other departments to share data and share information. So before we get into this stuff, if you do have workers under the age of 18, do review all of your practices and your wage and hour records and all of that, and make sure that you are in compliance with the child labor rules, both federally and at the state level, wherever they're working. So as we've been saying, do familiarize yourself with the state and local laws as well as the federal. So oftentimes, and as I'm sure you're aware, many states have their own minimum wage, for instance. They also oftentimes have their own child labor laws in terms of hours of work, hours per week, and restricted job duties and job functions. So familiarize yourself with those. Also, some states will even have rules on overtime calculations as well. So California, for instance, measures hours in a day. So at the federal level, you don't have to worry about overtime unless someone works more than 40 hours in a work week. Out in California, if they work more than 8 hours in a day, that triggers overtime as well. If you have employees that are being paid multiple rates, so this happens a lot in a lot of industries, but restaurants come to mind for me, where you might have someone that's working some hosting hours and some waiting hours and some bartender hours and maybe even some management hours. So you do need to make sure you're doing that calculation correctly. That's a little advanced and a little bit in the weeds to go over in a webinar setting, but certainly if you have concerns that you're not doing it correctly, reach out to us. We can go over some examples. We can do some math with you and help you out with that. For those of you who pay bi-weekly or less frequently, it's really important that you're calculating hours for purposes of overtime on a weekly basis. So even if you pay bi-weekly, let's say you do and you had an employee who worked 48 hours one week and 30 hours the next, you might look at that and say, well, they only worked 78 hours. They didn't work more than 80 hours. I don't need to pay them overtime. The Department of Labor would see that very differently and state that no, in the week that they worked the 48 hours, you owe them 8 hours of overtime. In this day and age, especially since COVID, telecommuting has become very very popular and much more widespread, and it makes it much more difficult for employers to track the hours that are actually being worked. So I know one of the main concerns, especially as employers who hadn't previously allowed virtual work did start allowing it, they were afraid that people wouldn't be working, that they'd be slacking off, that they wouldn't be at their desk, what have you. Sometimes very valid concerns. On the flip side, they also need to be equally, if not more, concerned that people are working more than their fair share and more than 40 hours and might be eligible for overtime. So it's important that you make it very clear in your telecommuting and virtual work policies what your expectations are, and that you're not authorizing work in addition to 40 hours in a work week without prior approval. If it does happen, then you do need to compensate for it, but you do want to set your expectations pretty straight. And, it's still being fleshed out in the courts a little bit, but there is an onus on employers to know when their employees are working. So if they're sending emails after hours or doing other things that are easily seen by the employer, then that's generally seen as they're aware that the employees are working and potentially working overtime. So you got to be pretty vigilant with that to avoid a messy situation. You also want to be careful when you're paying salary, especially to salaried non-exempt workers. So again, employers do have some freedoms in terms of how they pay their employees. They can pay them hourly, they can pay them salary, they can pay them piece rate, they can pay them a day rate, so on and so forth. But for employees who, based on their duties, do not meet the duties test, they are still considered non-exempt employees and eligible for overtime. So if you do pay employees a salary, but they are non-exempt because of the nature of their work, you got to be careful with that. You do have to be ready to calculate overtime should they exceed 40 hours. Also have to be careful with your designation as managers. So managers is sometimes a term that's thrown around a little bit loosey-goosey. You might have someone whose title is office manager, and they could very well meet the administrative exemption. They could be making significant decisions for the business, entering into contracts, doing strategic planning for the company, grant writing, whatever it might be. But if they're an office manager and their significant decision making involves ordering office supplies and ordering lunch and things like that, then most likely those are not going to meet the bar of the administrative exemption. Similarly, as we talked about before, and with that good question about volunteers and things like that, we have seen, and I've seen an audit, in a fast food environment where they had people as managers, and they really boil it down. They say, okay, who specifically is this person managing? And if it's not full-time employees, then they're adding up the hours. So if it's, if it's not two 40-hour-a-week employees, they will add the hours of those part-timers, and maybe it's 4 10-hour-a-week employees that counts as one. And then again, they are going for an equivalent there. So it's not so much counting the heads, it's counting the hours. So it's just some things to keep in mind, that just because someone has manager in their title, or even if they do have managerial responsibilities, you still want to run them pretty vigorously through that duties test. It is really also important to differentiate between using terminology that's someone's salaried or hourly, or exempt versus non-exempt, because the exempt versus non-exempt and being compliant with that is what's going to keep you out of trouble. Very often we'll start working with a business and we'll start asking some of these questions and work with them from a compliance perspective, and they might just kind of poo-poo it and say, oh, we pay everyone's salary, it's all set. We don't track hours, we don't have timesheets, we don't need to. So you really have to make sure that those salary decisions are justified based on the regulations. Definitely for your non-exempts, want to make sure that you're not making employees nor allowing employees. So again, that harks back to that virtual employee environment. Don't allow employees to perform work off the clock. Again, you want to have policies in place if it is intended to be your policy to not allow employees to work overtime without prior authorization. But again, if they do, you have to pay for it. It can certainly be a disciplinary issue where they get in trouble for it and get written up, or whatever your progressive discipline policy is. But if the hours are worked, they need to be paid, and paid accurately. For those of you who have worked in the public sector before, you might be familiar with comp time. It is generally allowable in the public sector, but is not allowed in the private sector. So what this would be is if you had a worker and they worked that 48 hours that 1 week, and you said, okay, take a day off next week to make up for it, and we'll just pay you the straight time. That is not okay. When the hours are worked in excess of 40, overtime needs to be paid. Comp time is not allowed. And then in terms of when you do have an overtime situation, you do need to determine what the regular rate is to base that 1.5 times off of. So again, we don't want to get too in the weeds in a 1 hour webinar here today, but the Department of Labor has made it very clear that non-discretionary bonuses, so things tied to certain performance metrics, commissions, and things like that, they do need to be factored in addition to any hourly rate when you come up with the rate of pay that overtime is going to be based off of. So again, if you need more information on that, reach out to us. We'd be happy to send along some information. But the regular rate, meaning including not just the hourly rate, but several other potential factors, is what overtime pay is based off of. All right, so in addition to classifying your employees correctly as exempt or non-exempt, making sure that they're being paid overtime accurately and properly, there are also record keeping requirements to the Fair Labor Standards Act, and definitely in a situation where a business is audited, this is something that is taken a look at quite closely. One important note here, and it kind of bridges these two topics, and something in talking with a business recently that they got nailed on in a Department of Labor audit, is that you want to reflect breaks, or at least meal breaks, in your timesheets, whether they're paid or unpaid. So while meal breaks aren't required from a federal standpoint, many states do require them, and it varies depending on how long the shift when you need to pay it. It is important to reflect those to show that they were offered. But for breaks that are less than 20 minutes, those need to be compensated. So again, I spoke with a business recently who was having employees punch out for 5-minute breaks, 10-minute breaks. The Department of Labor noticed that on their timekeeping records. They were found to be in violation and had to provide back pay for all of those little breaks that were not paid, in addition to some fines and penalties. So that's a really important one and a really topical one. If someone's going to be taking a break and you intend for it to be an unpaid break, it needs to be at least 20 minutes. And there were some recent court rulings over the last couple of years that solidified that stance. So again, if employees are taking small breaks, you need to strategize a way to do that and not be docking their pay for those short breaks. But generally speaking, you can use any type of timekeeping method you want as long as it's complete and accurate. So again, some people will use traditional time clocks. Some folks, especially in the hospitality industry, will use their POS system for punching in and out. Some people use electronic timesheets. Some people are old school and still have people fill out paper timesheets. All acceptable as long as they're complete and accurate, and can be attested to by the employee. If you have a situation where the employees work a set schedule every week, I'm thinking about certain banks and credit unions come to mind. I'm sure there are other applications as well. And their schedule never deviates. As long as it's, is permanent, is displayed, and you have a way to indicate that the schedule was followed, that's permissible as well. So we will send everyone a copy of these slides. Good idea just to click on that link and show what a complete time record looks like. Most modern timekeeping systems, payroll systems, if you use us and iSolve Time, the data that's produced out of that meets the FLSA requirements, but generally you need the name, the dates of the pay period, the exact hours worked, when they punched out for unpaid breaks, things like that. And then from a federal standpoint, those payroll records need to be retained for at least 3 years. Again, you're going to want to check your state regulations. Some states have document retention requirements that are much longer than that. As a rule, when people ask me at a high level, I'll say 7 years is generally safe from all federal, state, and different agency requirements, that if you're keeping your records for 7 years, you shouldn't have any violations. But from the federal standpoint, for payroll data, 3 years is the standard there. All right, so we are also including some Department of Labor resources. Again, as soon as we get any word on what the exact changes are going to be to the Fair Labor Standards Act and the overtime rules, we'll send out an alert to all registrants of this webinar. And again, my apologies that we don't have the data just yet, but we're working hard to get it. All right, so it looks like we do have some questions here. I don't know if you've taken a look at these at all, Emily, or want to field any, but if not, I can definitely dive in as well.
Yeah, absolutely. I did get a chance. Awesome participation, everyone. We got 15 questions answered already, and we still have about 6 open. So let's take a look at some of these. Paul, I kind of want to go maybe in order of when someone asked, because we had someone ask something at 1:16. So
Okay.
Please elaborate on 4 hours worked equaling full pay. So if an employee who is exempt takes sick time for 3 hours, can an employer require to take PTO, or if there is no PTO, deduct the pay for 3 hours? Any insight there, Paul?
Yeah, no, it's a great question. So generally speaking, no, when it comes to partial day deductions, if an exempt worker comes in and reports to work and performs any work that day, they do need to be compensated for the full day. Now, when it comes to their PTO balance, you can certainly reduce the PTO balance, but again, if that is exhausted, partial day deductions from an exempt workers' pay are generally not permissible.
Thank you.
Yep. Let's see.
Yeah, I know. I'm looking through them as well.
All right, great question here. Can I pay a part-time employee as exempt? If the position was full-time, it qualifies as exempt. But if I'm having someone work 24 hours a week, can I just pay them $24,000 annually? If they were 40 hours, they would be paid $40,000 for the same job. So the answer to that is, first, yeah, technically a part-time worker can be exempt. They don't factor in how many hours they work as part of any tests. It's all about the job duties first. So if the job duties are exempt in nature, you check that box. If they're paid a salary, you check that box. The rub is that there is no proration allowed of that salary amount. So for someone to qualify as a part-time exempt worker, they need to meet the full salary basis test. So again, that's going to be your $35,000 and change right now, likely to increase in the near future. So unfortunately, when it comes to those part-time workers, to be exempt, they do need to meet the full salary amount as part of the salary test. Emily, I know you typed in some answers to several questions here. I don't know if you'd like to, I know sometimes the group can't always see those for attendees. So I don't know if there's a couple there that you'd like to
that sounds
read
great.
off.
Yeah, we had some great questions come in, and some were really specific to certain job titles. So one of them that came in was if we could elaborate on a job title such as an accounts payable specialist or an accounting exemption. So what I answered here is that obviously proper classification relies on a thorough understanding, just like Paul said, of the employee's actual job duties and responsibilities day to day. But if the role, just general knowledge, if the role involves significant decision-making or analysis, maybe financial management responsibilities, it might be more likely to qualify for exemption. Just remember that the accurate classification requires a careful examination of all the relevant factors, keeping in mind, obviously those local labor laws and regulations as well. So I would need a little bit more information in order to properly classify that position. I would need to review the job duties, and we would have to go through those different types of tests to properly classify. So it's really going to depend. So it's more of a general answer. But I generally said, this type of position may qualify under the administrative or learned professional exemption, just from what I know. So I hope that was helpful.
Yeah, as much as we'd love to field job titles and let you know whether they're exempt or non-exempt, there's so much intricacy in the details to be able to give an accurate determination there. So we're happy to share our thoughts and kind of what we've seen out there as common examples. But as I'm sure you're all aware, when you think about maybe your competitors or other people in your field, who have the same job titles as you, the day-to-day that they're performing might be very different.
Exactly. I got another question too, I thought was good. So they asked, paying salary based on working day by day. For example, we pay employees 8 hours for each day they clock in. Does this not count as salary? Basically paying employees based on the number of hours they work each day, which can commonly be known as like a day rate or hourly pay. It may not meet those requirements for that salary basis test that we went over in today's training under the FLSA, and other, similar labor laws. So the salary basis test is definitely a criteria for determining whether an employee is exempt or not exempt, and the number of hours they work each day isn't going to be enough to determine that.
Yeah, and especially when you look at that Supreme Court case I mentioned earlier, really anything short of a weekly or less frequent salary amount is going to jeopardize the exemption there. So anything short of a guaranteed weekly salary amount, or it could be, monthly, but they're always going to look at it on a weekly basis, but you really got to look at it at least that level to qualify.
Yeah, absolutely. So a lot of them, we did get a lot of questions just based on like specific positions, and I kind of answered it the same way as we were just discussing. So and some people asked for a copy of the recordings. We'll definitely, as Paul mentioned, we'll be sending a copy of the presentation after the webinar. Trying to look at some of the other questions here.
Yeah, no, we're running short on time. We will type up some responses to some of these and then send those out to everybody. Maybe one here that's a good one, when asking about comp time. So I kind of poo-pooed that as something available in the private sector. Someone asked, is that something potentially available for exempt workers? Yeah, definitely. So you got to navigate it carefully so you don't jeopardize the exemption and make it seem like they're being paid by the hour, and that there's going to be something directly tied on an hour by hour basis for the hours they work in addition to 40. But if you want to throw someone a day, if they've been working a lot of long days or long hours, or even come up with a financial incentive for someone who's worked more than they normally are, there are ways to do that without jeopardizing the exemption for sure. But yeah, no, thank you so much. These are some really, really great questions here. We will take some time to draft up some responses to these and again, get these out to everybody. But we are running up on the hour, and I want to allow Brianna some time to close us out and talk about the next exciting topic we have coming. So thank you so much, Emily. It was really fantastic partnering with you on this, and
You as well.
I'll hand it over to you, Brianna.
All right, thank you, Paul and Emily. So to learn more about MP's full service solutions for 2023 more, I just dropped a link in the chat that will connect you with an MP team member. You can also visit our website at mphr.com for more information. Be sure to join us for our upcoming webinar, Pay Transparency Unveiled, Laws, Best Practices, and Compliance Alerts. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.